All right. Good afternoon, everyone. Can everyone hear me in the back there? Yes? Awesome. Usually my wife tells me keep it down a little bit, so I'm glad everyone can at least hear me. My name is Brett Yaw, and as Karen said, I'm an attorney with Ford Harrison. And today, we are going to be talking about reaping the benefits of a harassment-free workplace. You know, we always hear about, and we're going to talk about the Me Too statistics that we've seen since October of 2017. But I really want you to think about what are the positive things that we can take away from a harassment-free workplace. And when you leave here today, I don't expect you to be an expert in harassment. I don't expect you to go out and say, you know what, I'm gonna try my very first harassment case. I am an expert in sexual harassment. What I really want you to do, and what I really want you to take away from today's presentation is, what are the types of behaviors that we want to eliminate in our workplace? What are the types of things that can be construed as harassment? And I really hope that you have a much more broad understanding of just what harassment is in the workplace, because I think it's, as we'll talk about, it's easy to pick out the obvious ones. It's not so easy to pick out the things where you say, you know what, I don't really think that's harassing behavior, while someone else might think that it is. So again, our objectives for today is I want you to be able to understand legally what harassment is. I want you to understand why it's important to prevent harassment in the workplace. And finally, I want you to understand what your responsibilities are as an employee. So to get started, why am I here? Well, really, as Karen alluded to, we've had this Me Too movement known as it started as the Weinstein effect. It's this global trend where we have accusations against famous and powerful men of sexual misconduct. And it started after numerous allegations of abuse against film producer Harvey Weinstein. And as I was preparing for this presentation, reviewing this material, going back, when did this all start? It was only first in October of 2017 that the New York Times first reported these accusations. If you think about it, that's really only 16 months ago. And it feels like every day this is now in the media. It's been around forever. And it really hasn't. This is a much more recent trend that we're seeing. The Me Too movement started shortly thereafter with a tweet by actress Alyssa Milano. And on Facebook, more than 12 million posts, comments, and reactions regarding Me Too were reported within 24 hours by 4.7 million users worldwide. On Twitter, we saw over 1.7 million tweets that included the hashtag Me Too. So this really was a groundswell of activity. Since 2017, October 2017, we've had a lot of high-profile names be accused of sexual misconduct. In November 2017, the LAPD reported having 29 open sex crimes investigations involving Hollywood and media figures. And this atmosphere has really led to a lot more sexual harassment investigations and reports that have led to terminations and resignations of high-profile and powerful individuals. I don't think it's any surprise that you could turn on the news any given week and see someone who's resigned after accusations of sexual misconduct. Reports are continuing to surface almost every day, if not every week. And so what we want to do, and what employers are now doing, is we want to take proactive means to effectively end harassment, strengthen our policies and procedures, develop and implement training, is now, again, really at the forefront of not only employers but also legislators. And I think I'm going to give you some statistics, and if you don't have a copy of the presentation, I know that there's additional copies in the back, but the next few slides have a lot of statistics in them. We'll go through them, but I really, as we talk about them, I want you to understand and look at and appreciate the differences of opinion, right? So not only is it differences of opinion about what sexual harassment is between men and women, it's also differences between race. There's also differences between generation. And what all that is to say, really, in my mind, is that harassment, sexual harassment, it's very much based on perception. Again, what I think is sexual harassment might not be what somebody else thinks is sexual harassment. So at the outset, I believe that last slide, before we skip too far, almost 60% of women have reported experiencing sexual harassment in the workplace. This poll that we had looked at in 2017, again, revealed different viewpoints about what constitutes sexual harassment. For instance, most adults agreed that acts such as intentional groping or kissing without your consent amounted to sexual harassment. Again, some of these we think that's pretty obvious. However, unwanted compliments about your appearance were viewed very differently. 38% of adults said that this amounted to sexual harassment, while 47% said it didn't. Again, that's almost not just an even split about what constitutes sexual harassment regarding comments about someone's appearance. 41% of adults said they thought it was sexual harassment when someone told you a dirty joke, but 44% said, no, that's cool with me. 44% said that non-consensual hugging was sexual harassment, while 40% said it wasn't. And you might think to yourself, Brett, we're here today talking about hugging? Is this what it's come to? My gosh, what are we talking about here? Why are you standing on a stage talking about non-consensual hugging? Come on. We'll talk about it more with behaviors to avoid, things to be on the lookout for. But I've done an entire sexual harassment investigation, spent thousands of dollars of a client's money doing an investigation only on non-consensual hugging. And I'll tell you all the details about that, but think about that. $10,000 on an investigation into non-consensual hugging. I mean, so this is, I think the important thing to take away is whether we agree with it or not, harassment is very much based on perception. 19% of men said that touching someone intentionally without their consent was not sexual harassment, compared with 11% of women. Poll didn't really specify what non-consensual touching meant, but again, you can see the difference between gender. 52% from racial minorities said that they considered non-consensual hugging to be sexual harassment, compared with 39% of Caucasians. Most adults said that they thought it was sexual harassment to send pornographic pictures to someone without their consent, but younger people appeared to be more permissive. 83% of millennials said it was sexual harassment, compared with 90% of Gen Xers, compared with 94% of baby boomers. So again, that's not a large spread, but it's still 11% difference between millennials and baby boomers. So again, what I want you to take away from this is not necessarily what these statistics are, but what they mean. And what they mean is that harassment is viewed differently across race, across gender, across generation. Unfortunately, reporting is the least likely response to sexual harassment. According to some studies, only about 30% of individuals who experience harassment in the workplace will actually report it to their supervisor. Only 6 to 13% will actually file a formal complaint. Unwanted touching is only reported 8% of the time. And sexually coercive behavior was reported only 30% of the time by women who experienced it. Those numbers, I just want to go back to those for a second. These numbers should be 100%, right? We would want employees to report this type of behavior 100% of the time. And so the question is why? Why aren't our employees and why aren't these individuals actually reporting this type of behavior? All right, so I want you to think, as we go through this, kind of think about what are some of the reasons why that wouldn't happen. But I think it's worth noting that if in my perfect world, these would be zero because there would be no harassment, right? But again, what we want to do and what we'll talk about is if you see something, say something, right? Or if you experience something, say something, because these numbers are far too low. We want these reporting statistics to be much higher. So now that we've talked about perceptions of what is harassment, we're actually going to talk about what is harassment. So harassment is any unwelcome verbal or physical conduct, meaning you have not asked for it, you have not welcomed it, and you do not consent to it. And it can be based on any protected category. I don't want you to leave here today and say, well, Brett only really talked about sexual harassment, so harassment on other categories, that must be fine. It must be fine to engage in racial harassment or religious harassment. That's not what I'm saying. Harassment can be based upon any protected characteristic, and I'm going to give you a slide about what those protected characteristics are. They include sex, race, religion, national origin, age, disability. So harassment is a much more broad concept than just based on sex or sexual harassment. As I said, Title VII, the ADEA, that's the Age Discrimination and Employment Act, the Americans with Disability Act, and state laws. Here in Florida, we have the Florida Civil Rights Act, make it unlawful for an employer to discriminate against an individual with respect to compensation, terms and conditions of employment because of an individual's race, color, religion, sex, national origin, and to limit, segregate, or classify employees or applicants for employment in any way which would deprive or tend to deprive an individual of employment opportunities or otherwise adversely affect status of an employee because of one of those protected characteristics. It's a mouthful, right? What does that actually mean? It means we can't treat people differently based on those protected characteristics. That's what we're really talking about. And what types of actions are we talking about treating people differently? The terms and conditions of your employment. Although harassment is not included in any of the federal statutes, long-standing case precedent includes the prohibition of unlawful workplace harassment. And the reason is because the conduct is because of an individual's protected classification, where you have a workplace that's so permeated with discriminatory intimidation, ridicule, and insult that the victim's terms and conditions of employment are changed, that's when we have harassment. That harassment is discrimination. So I want to make sure that we all understand that harassment is prohibited by state and federal law. This is not just me up here telling you, hey, don't do that. That's not good. It's actually prohibited by state and federal law. So as I said, harassment isn't just sexual harassment. It's not just based on sex. You have a whole host of characteristics that are unlawful to harass. Again, you have sex. You also have gender. And you might say to yourself, well, Brett, what's the difference between sexual harassment and harassment based on gender? Sexual harassment is actually based on the sexual nature of the harassing behavior. Harassment based on sex is based on someone's gender itself, harassing someone because they are a man or because they are a woman. Recently, we've also seen claims brought where you have claims of sexual orientation or gender identity or transgender status harassment. You have race, color, national origin, disability, religious, age, pregnancy, marital status, whether you are or not married, veteran status, harassment based on genetic information. All of these types of harassment are illegal. So again, it's not just sexual harassment that we're concerned about. It's not just sexual harassment that I'm concerned about. It's all of these different types of categories, and they're all illegal. So who, where, when, and why? Where can harassment occur? I think it's a common misconception that only men can harass women. And while that is true, women can harass men. Men can harass men. Women can harass other women. Supervisors can harass subordinates. Subordinates can harass their supervisors. Third parties can harass employees. Our employees can harass third parties. Really, the takeaway is everyone can harass everyone else. So there are no bounds on who can harass who. I want to spend a couple of seconds talking about the third and fourth from the bottom bullet points about third parties. Just because we have a non-employee who is engaging in the harassing behavior doesn't mean that they can get away with it or that that's fine. I'll give you an example. If we have someone who delivers packages to our workplace, or a client that comes into our workplace and engages in harassing behavior, that's not okay. That's not permitted. And the law prohibits that. And we'll talk about some ways in which we can report that, but I want you to be aware that that's unacceptable conduct. On the flip side of that, if we have customers, clients come to us and we harass them, that's also prohibited. So I want you to think about it's not just employees. It's not just employees and supervisors. It really is anybody that we engage with in the course of our day, in the course of our employment. And it does not matter to whom the harassing conduct is directed. I think that one is really, really important. So I'll say it again. It does not matter to whom the harassing conduct is addressed. And you might be saying to yourself, well, what does that even mean? You're such a lawyer, talking these weird terms. Come on, what is it? But break it down for me. So I'll give you a really easy example. So if there are two people in the hallway talking about something, maybe it's sexually explicit, and you have a third person walking down the hall and overhears that conversation. That person who overheard the conversation can report that as harassing behavior, right? Just because they are not the subject of the conversation and they've only overheard it, they can still report that as harassment. I'll give you an example, real life example. We had a client that called me and said, Brett, we've got a situation. I said, okay, what's going on? We had a supervisor who was sending sexually explicit text messages to a subordinate's fiance, a non-employee, right? So subordinate's an employee, the fiance is not an employee. I talk to the supervisor and I say, what's going on here? And he's like, yeah, I sent those messages. What's the big deal? She's not an employee. Well, I don't understand why we're all up in arms here. Might I be creepy? Sure. But I didn't do anything wrong. This isn't illegal. She doesn't work here. Well, as we talked about, it doesn't matter whom the conduct is directed to. We had the subordinate, that employee, who was ready to quit over his supervisor's actions. He was ready to say, you know what? This has changed the terms and conditions of my employment. I am so upset about this, that you are doing this, that I'm ready to go, right? So eventually we ended up letting that supervisor go because of his conduct that was directed at a third party. Again, the subordinate, he wasn't getting those text messages, but still he was offended, he was upset about the nature of those photos and reported it. So again, I want you to think that it's not just, it's conduct immediately directed at that person. It really is whomever hears it, observes it, whatever the case may be. Another example, not so much anymore, but it would be screensavers. Or the Sports Illustrated swimsuit edition calendars, or the hunky fireman calendars posted up in the workspace. You could have concerns about those as well. Again, I want to touch about harassment by non-employees. As I said, it is prohibited, number one, but any employee who becomes aware of such harassment, we have to report that to HR. If we have customers, clients, whomever, engaging in harassing behavior with us, or behavior that makes us uncomfortable, it might not rise to the level of sexual harassment or harassment, but that we know there's just not something right there, we have an obligation to report that. My example for you, this is a real case. You had an employer, a franchisee of a national chain, who was actually found liable for sexual harassment when its manager ignored an employee's complaints of a customer who was sexually harassing her on 2 occasions. The franchisee ignored a corporate policy that managers should first inform the customer to stop sexually harassing their employees and then ask the customer to leave if they persist after the first warning. So again, if we see that type of behavior or we experience that type of behavior, we have to report it. We can't think, oh, It's just a third party. My employer's not going to do anything. There really is no recourse for me. I don't want you to think that. I want you to think immediately, I need to report this. I need to make sure somebody knows about this type of behavior. So where can this behavior occur and when? So obviously it can occur at work. It's called workplace harassment for a reason, right? But it can occur off work. Work-sponsored events or functions. And it can occur anytime, day or night. And where we're really seeing this new area of harassment is online, on social media. We are seeing more and more where we have complaints of employees who are engaging in inappropriate behavior across social media, whether that be Facebook, whether that be Instagram, whether that be Snapchat. Employees, for whatever reason, and people, for whatever reason, have this tendency to think, if I send inappropriate messages over Facebook, it's outside of work, it's on my time, and it's outside of the workplace. This has got to be fine, right? No, it's not, and it's inappropriate, and if the employer finds out about it, it has an obligation to take affirmative action to end it. So I want you to think about and remember these laws extend beyond just our physical workspace. They are now in the social media realm as well. On the flip side of that, if we are the recipient of one of those messages that we feel is inappropriate, harassing, then we need to do something about it. We need to say something about it. If you take nothing more from this, I have absolutely co-opted that phrase, see something, say something. We can't do anything about it. We can't correct the behavior if we don't know about it. So the location of where these things can occur, again, it can occur within the employer, it can occur on site, again, and that's with vendors, customers, clients, third parties. Remember, everybody can harass everybody else. It doesn't matter who you are. And it can occur off-site as well. Company-sponsored functions or non-sponsored functions. This can occur if you have a group of employees who are just out after work at a restaurant or a bar, hanging out, having a drink after work. Again, it doesn't have to be within the four walls of our workspace or within our work location. So the legal basics of harassment. There are two forms of harassment. The first is quid pro quo, which is just a Latin phrase which means this for that. This happens with supervisors and subordinates. And an example is, I'll give you a raise if you go out on a date with me. Right? That's quid pro quo harassment. Hostile work environment is where you have a conduct that's creating an intimidating, hostile, or offensive work environment. And I want to go back to that because hostile work environment is one of those phrases that I find in what I do is one of the most misused phrases that I've come across. Just because we have to report to work at a certain time or have to work with our certain supervisor or have to deal with Brett who's wearing a white and blue and reddish shirt and I really don't like those color combination with gray, that doesn't make it a hostile work environment. What we're really talking about is this conduct that's based upon one of those characteristics that I gave you before that's creating an intimidating, hostile, or offensive work environment. That's really what that means. It's not, Brett, you've really got to tone down the cologne. It's your cologne is making this a hostile work environment. We might need to talk to me about my cologne usage, but that's not what hostile work environment means. So I said the conduct has to be unwelcome. So what does that actually mean? Well, an employee that's receiving the conduct didn't solicit or invite it. The employee regarded the conduct as undesirable or offensive, and we're using a reasonable person analysis here too. And you might say, Brett, here you go again with these legal terms, reasonable person. I don't know what that is. What do you mean? It's a little difficult to explain. I am not a law professor for a reason. But harassment has two components. You have a subjective component with the individual who thinks that this is harassing, and then you have this reasonable, objective person, which theoretically the law creates this person under normal sets of circumstances, whether that objective, imaginary person would consider this harassing as well. So sexual harassment, kind of putting it all together, is unwelcome, is sexual or sex-based, is conduct that adversely impacts an individual's ability to do his or her job, and is considered discrimination under Title VII, which is our federal law, as well as the Florida Civil Rights Act. So you might say to yourself, okay, well, Brett, you know, we're talking about sexual harassment, you're talking about potential liability for employers. I'm fine to harass people, right? Like there's no, you haven't said that there's individual liability for this yet, other than potentially losing your position over it. But there is personal liability for engaging in these types of actions that might result in sexual harassment. So there are personal liability for torts, such as assault, and battery. Those two terms get mixed up a lot in what I do, but assault is when someone fears that an imminent touching, unwanted touching is going to occur, and battery is when that unwanted touching actually occurs. There's also independent causes of action for defamation, false imprisonment, intentional infliction of emotional distress, negligent infliction of emotional distress, and the statute of limitations to bring these claims against a purported harasser might be years long. So not only do we have to worry about what our employer is going to do, and like I said, disciplinary action, if the action is corroborated, will result, but also you have these independent torts as well. So remember, it makes no difference what the alleged harasser thought he or she was doing. And what I mean by that is whether the harasser thought that the remarks or gestures or touchings were flattering, complimentary, or nice, doesn't matter. We don't take intent of the harasser into consideration when we look at was something harassing or not. We evaluate harassment complaints in part on the alleged victim's perception and point of view. So what do we do? No one? No one? Okay. That's okay. I didn't give you a prompt. We have a policy, and all of you received the policy today. You should have already received it. If you haven't, you probably should raise your hand so you get a copy. Your policy defines harassment. We talk about what zero tolerance means. We talk about what reporting mechanisms we have. If we have a concern, where do we go with it? It also talks about non-retaliation. Again, you might say to yourself, Brett, what does that mean? It means if you bring a complaint of harassment, or you saw something and thought, hey, Brett said see something, say something, I'm saying something. We're not going to retaliate against you. We're not going to take adverse action against you just because you told us about risky behavior that you observed in the workplace. And we also talks about confidentiality and to the extent at which we can give it during an investigation. And we talk about, well, Brett, why are you here? Why are we doing all of this? We get it, we get it, we get it. What we're doing is creating a culture against harassment. If we can eliminate bad behavior at kind of this ground level, right, we're never going to get to the level of evaluating, is this a hostile work environment? Is this unwelcome behavior that has changed someone's terms and conditions of employment? Because again, we've eliminated that type of bad behavior. Because the last thing that I want and the last thing that you probably want is to sit down in a room with me and have me say, why did you do that? What were you thinking? What did you do? Why did you do it? Because really, no one, number one, really wants to spend that much time with me other than my wife, God love her. But number two, it's probably not going to end well. So even our best, harassment policy can still be undermined. And that's really my plea to you all, is to really help us create this culture against harassment. So offensive comments about men and women in general, that can be undermining our policy. Stereotyping capabilities or work ethic. Sexual jokes in the workplace. I can tell you, and we'll talk about jokes, but I don't know of any joke that's worth my job, personally. That's just me. Allowing pornography to be viewed in the workplace. And you might say to yourself, Brett, get out. It's 2019. People don't do this stuff anymore. I just had a call about this the other day, literally. I had a call last week with an employer saying, hey, we've got somebody that's been watching pornography on their phone. What do we do? My advice was, you move forward and separate, because that's inappropriate and it's not permissible. And allowing employees or customers to be rated by employees, hot or not. Putting people on a scale of whatever category you like. Again, all not appropriate, and all these things do is undermine our culture of compliance and our culture against harassment. So again, your policy has a clear definition and a clear explanation of prohibited conduct. But we're going to go into some conduct that could create claims of hostile work environment. Unwanted sexual advances, again, that one seems fairly obvious. Multiple requests for sexual favors, other verbal or physical conduct of a sexual nature, off-color jokes, either written, verbal, or electronic. This would be, oh my gosh, I saw this hilarious joke or this hilarious meme online. Let me forward it to somebody because this is great. You're going to love this. And again, remember that conduct may be from non-employees or employees. Again, that goes both ways. Non-employees to employees or employees to non-employees. Either way, it can cause issues. So we have pictures, books, magazines, emails. Not so much faxes anymore, but you'd be surprised. The internet is certainly a big one. Pictures, hey, look at this. Posters, pinups, again, that's, these physical workplace items still exist, but again, this is more to give you the types of things, types of categories that can create that risky behavior that we don't want. Comments, oral, written comments, silence. You might say, Brett, I don't understand what a silent comment is. That would be these inappropriate gestures that you have at the bottom. It can also be leering at people, giving people strange looks. There was actually an entire case about the silent looking back in the 90s. In that case, you had I won't bore you with all the details, but this employer had an open workspace. And the manager was in the corner. Manager had a glass office. And an employee felt that every time that she kind of got up from her desk, the supervisor was just staring at her, and just leering at her, and just uncomfortable. Like every time she got up to go do something, the supervisor was just looking at her. There were no allegations of physical touching, just these leers and stares. That provided a basis for a case that lasted several years, cost the employer hundreds of thousands of dollars in legal fees. So you might think, Brett, innocuous looks, really? We're at that? The answer is yes, we're at that. Jokes, pet names. The one that I've, for pet names that I've actually investigated was I guess a phrase used in King of Queens. I'm sure it's been used other places, but the work wife. We had a doctor's practice where the physician referred to his nursing assistant as his work wife. The guy was as genuine as could be, meant no harm by it. I had to do an entire sexual harassment investigation based upon this calling of work wife, this pet name. Gossip and rumors, put downs, lewd references to pornographic material, comments on personal appearance that create sexual innuendos, when we're telling people, hey, you look nice today, hey, or gosh, that top looks great on you today, or Brett, I really like those pants. Things like that, comments about personal appearance, that can create issues down the line if we're talking about comments that are being based on sex. Touchings. Again, you might think, Brett, we get that grabs and kisses, we understand that that's probably not going to be appropriate in the workplace. But why is number one hugs? What did hugs ever do to you? Were you not loved as a child, Brett? Hugs is number one because it is innocuous. We think of hugs as, you know, it's a hug. If the hug is unwanted, we might have a basis for sexual harassment complaint against us. I told you I was going to have a hug story, so here it is. Several years ago, I got a call from a client saying, Brett, we need an investigation done. So, okay, what's going on? The complaint was we had a supervisor who was hugging a subordinate. So, okay. Talked to the individual who complained, and she said, Brett, I can't get away from him. Every time I come to work, he comes over and gives me a hug, and it lingers, and it's just, I don't like it. And then I leave, and then I get another hug, and it's creepy. And then I'll be sitting at my desk, and they'll come over and put his hand on my back and give it me a little squeeze. And it's creeping me out, Brett. I just couldn't deal with it any longer. It's like, oh man. Talk to the supervisor, sitting in a conference room. He comes in, tries to give me a hug. And I'm like, ew, whoa, it's not what we're here for. So I sit him down, say, here are the allegations. Can I have your side of the story? He was aghast. He's like, Brett, I come from a long line of huggers. My mom was a hugger. My grandma was a hugger. My dad was a hugger. I'm just a hugger. It's what I do. It's what defines me as a person. And when I give you a hug, I'm so glad to see you today. I value you as an employee. I value the work that you do for us. And I'm just genuinely happy to see you. Okay, what about these grabs? It's like, well, that's just me telling you, you know what, you're doing a great job. I see you working hard. I see you getting the hours. And you know what, that my hand on your shoulder means, you know what, I see you. And I think you're doing a great job. I said, well, did you ever communicate that to this employee? No, did I need to? So you can see, something as innocent as a hug, as a pat on the back, can be misconstrued as something completely different. In that case, the supervisor thought that he was being an awesome boss by saying, I value you. Great job, let's keep it up. On the flip side, you had the employee who perceived that innocent behavior is creepy and not appropriate for the workplace. So again, that investigation cost tens of thousands of dollars for me to go through, investigate, write a report to say, you know what, we had a communication breakdown here. That's not to say, and I'm not saying, don't ever hug anybody else. I understand that, you all have colleagues that you're close with. My goodness, I saw the service awards earlier today. That's awesome. You all have great working relationships with your coworkers. So I hope you don't leave here and say, you know what, Brett said don't hug me. Keep away. I can't hug you. But what I am saying is, again, that type of conduct needs to be unwelcomed. And if you don't know somebody and you're a hugger like the guy in my example, it doesn't hurt to say, hey, I'm Brett. Nice to meet you. Can I give you a hug? And if the person's cool with it, they'll say, yeah, give me a hug. That sounds great. If they're not, they're going to say, no, I don't want you to hug me. And you say, hey, that's cool too. I get it. But it's about understanding that it's not what we perceive as harassing behavior. It's what the other person perceives as. So again, it might seem like overkill. You might sit there and say, you know what, Brett, you're like the fun police. This is crazy. I think the easiest way for us to move forward is to say, yeah, you know what, it is crazy, but This is the world in which we live. We don't want to be, and I'll give you some kind of things to take away, some best practices. We don't want to be on the flip side of that investigation where I'm sitting you down and saying, why were you touching someone without their consent? And you say, well, Brett, I was just giving them a hug. And I said, well, did you ask? Did you write that down in your presentation materials? He said, no, I didn't. Okay. So again, all of this is for your benefit. Same thing with touching someone on the back. Again, it's all about perception. Going back to my list, massages, bumps, looks, and then again, touching others in a sexually or offensive manner. Propositions, this kind of goes back to our quid pro quo, but also our just general hostile work environment. Propositioning someone either by orally, written, email, making statements to people, repeatedly asking someone out socially after being turned down. That's the it's no longer the cute thing to go after the coworker to repeatedly ask them out and say, oh man, they're just playing hard to get. No means no. It's not no means no until no means yes. It is no means no. So just kind of keep that in mind. And the last one is do X or else. That was my earlier example of go on a date with me and I'll give you a raise. Or if you don't go on a date with me, I'll report you to HR for something inappropriate. Other conduct, again, I'm going to keep stressing it. It's not just sexual harassment that's inappropriate and illegal. You have other conduct as well. Racial, age, ethnic, gender, or religious jokes and comments, not appropriate. Screensavers and calendars of nude, partially nude men and women, not appropriate. Practical jokes with sexual overtones, unwelcome love letters, repeated or unwelcome pressure for dates, sexual innuendo, comments and jokes, or viewing pornography where coworkers can see, or just in general in the workplace. Again, my tried and true example is this joke worth my job? Again, me personally, the answer is going to be no. And you might say to yourself, well, Brett, this joke, it's killing it. I'm going to tell the joke about the priest. Is it worth your job? Is my response. And if the answer is no, then maybe don't say it in the workplace. Maybe save it for somebody else, but it's not appropriate in the workplace in talking to coworkers or these third parties that we interact with. And as I mentioned zero tolerance earlier, I want to make sure that I'm clear about what zero tolerance means, because there's this perception that zero tolerance for this type of behavior means, you know, we're coming down and it is immediate termination, no ifs, ands, or buts. Zero tolerance means that we're not going to tolerate the harassment based on any of those protected characteristics. And that prohibition extends to everybody in our workplace. But it doesn't necessarily mean automatic termination. It means that we are going to look into those complaints, look into those concerns, see what evidence we have, and then make a determination based upon the severity of the conduct, the evidence that we have, and we'll see what happens. Certainly termination and separation can result as the end of workplace investigations. It could also result in discipline. It could result in, we can't corroborate these allegations. Remember, here's what our harassment policy is. We need to make sure that you're following it. So zero tolerance means we are not going to tolerate this type of behavior in our workplace. So, policy. When was the last time you reviewed your harassment policy? The answer should be today, right? Kind of dovetailing, do you know how to report harassment? And if you didn't just get the policy today, if I asked you, how do you report harassment, would you have known? Would you have known to whom you actually report that harassment to? Would you know the types of behaviors to avoid? Did you know that retaliation for bringing these concerns to us is prohibited? Again, it's worth mentioning that our harassment policy is just as important as any other policy that we have in our handbook. We need to make sure that we understand what it says. We need to make sure that we know the types of behaviors that are prohibited. Because if we don't, and we make that sexually based joke, turning around and saying, well, I didn't know that that was inappropriate. You're disciplining me for telling that joke. It was a crack up. It's not okay. The ignorance of what this says is not a defense. My kind of admonition to you is don't overlook or shrug off risky behavior on any level. If you see unprofessional conduct, whether you think that it arises to sexual harassment, harassment based upon any of our other characteristics, address it. Okay? Unprofessional conduct doesn't belong in our workplace no matter what. Like I said, if we get rid of that behavior at kind of this ground level, we're never going to be at that point where you're sitting in a room with me and me asking you what happened. You should be adhering to your policy in all respects. And again, you're just getting a copy today. Take the time to read through it. If you have questions, certainly this is the opportunity to ask HR and say, hey, Brett said this, our policy says this too. What does this mean? I'm really not clear on that. HR will be able to provide you with that guidance. So, what must an employee do if he or she is subjected to or witnesses sexual harassment? This is for all of us. Not everybody all at once. I heard it. Oh, where did I hear report it? I heard report it. So I'm going to ask you again. What must an employee do if he or she is subjected or witnesses sexual harassment? Okay, still a little. One more time. I'm not going to let it go until we're all on the same page. What must an employee do if he or she is subjected to or witnesses sexual harassment? Report it. Much better. What are your responsibilities? We talked a lot about what is prohibited. What are we supposed to do? Obviously, number one, we're supposed to know and comply with our policies. We're supposed to report incidences that you experiences or you witness immediately. This is not one of those things where we sit around and say, you know what, I'm going to wait on this for a couple weeks and see if this just blows over. If you see something, say something. And cooperate with investigations. That's how we figure out what's happened to make sure that these types of things don't continue to happen. And you all have a role in promoting respect and dignity. And this is the last thing that I'm really going to leave with you. And I think that this slide will help encapsulate us, what I'm trying to tell you, because, again, no one wants to lose their job over a joke or a comment. So, number one is be a role model for good behavior. Be squeaky clean. You do not want to leave yourself vulnerable to trumped up complaints. Language. Watch the cursing, the nicknames, the jokes, the offensive conversations, the emails, the posters. Ask yourself, could someone perceive this as sexually harassing or harassing based on any other protected characteristics? Again, physical actions, whether innocent or not, can be misconstrued. Make sure if you are engaging in a physical action towards somebody, you know exactly how they're going to perceive it. Ask yourself, does it pass the mom or kids test? Would I tell this joke, make this comment to my mother or my kid? I have an 11-month-old son. I want to put earmuffs on him and surround him in saran wrap and never let him leave the house. So you better be sure that I'm not saying anything in front of him. And last, would you want what you just said or did to be reported in the news or read aloud before a federal judge? If the answer is no, then don't do it. So, with that, do we have